Hello and welcome again to Employment Law Show. Good to have you along for the next 30 minutes. Lots to learn, so stick around. John Scholes here. Beside me, of course, Lior Samfiru, co-founding partner, Samfiru Tumarkin, LLP, the most positively reviewed law firm in this country. When you're not watching the show or doing the show, you can reach out anytime to Lior and his very capable crew, always ready to have a chat with you. 1-855-821-5900, help@employmentlawyer.ca, right? And the website built for you. It is free. It's anonymous, called pocketemploymentlawyer.ca. There is much to be learned on that website. Even before you make the phone call to Lior, you can go to that website free and look around, learn lots. Also wrapped up into that, baked into it, is the severance pay calculator, which we will refer to guaranteed a couple times on the show today. But you can use it anytime to find an accurate number of what your severance really should be. If you have an offer on the table, or if you've just recently lost your job, or you think it's coming down the pike, you want to know what you're owed, accurate number. That's the best place to find it, other than a phone call, of course, to Lior. Lior, today, fast facts about bonus payments. That's on the show in just a bit. Stick around for it. It's going to be really interesting stuff. But we always start off with the week that was, the case of the day, pal. What do you got for me, or us?
Hey, John. Always great to be here. Always great to talk about employment law. Excited because I've been solving a lot of problems, and I know the types of issues that our viewers are dealing with, because I speak with them every day, every week. So if you're dealing with a workplace issue, number one, chances are you're not alone. And chances also are that I've dealt with it, I've spoken to someone about it, and I've already resolved it. So if you have an issue, don't hesitate to call. Make that call. Let's talk about your rights. You have extensive employment law rights across the country, okay? You really do. Oftentimes I hear people frustrated, oh my God, the laws favor employers. Well, the reality is the people that say that don't necessarily understand and appreciate how good of an employment law system we have in this country. The laws ultimately do favor employees in Canada, and you can understand a lot whether you've lost your job, whether you're worried about losing your job. Maybe you're being bullied or mistreated in the workplace. Maybe you think your job is being changed unfairly and you've been given an ultimatum. There's options and rights that you have in all these scenarios and more. And what we do on the show every week is tell you what you need to know so that you don't get taken advantage of, so that you know what to do if your rights are ever called into question. And to give you an example of the types of situation that I deal with, that I, of course, encourage you to call me about as well, let me tell you about a situation that came across my desk over the past week. I spoke with a lady who had been working for the same employer for a number of years, and up until the pandemic started, she always worked in the office, kind of a regular Monday to Friday, 9 to 5 job. Well, during the pandemic, she and all her colleagues began working remotely, like so many other employees. And she had been working remotely for now a couple of years. So she spoke to her employer and said, well, since I'm working remotely, do you have any issue with me relocating? I don't need to live close to work. I'm going to move away. I'm going to probably move a couple hours away, and I'm assuming I can continue working remotely. Employer said, yeah, no problem. You can move wherever you want. We're not going to need you back in the office. So that's absolutely fine with me. So she did that, and she moved away. She was quite happy where she is. Well, fast forward about 6 or 7 months later, her employer sends a message to her and all employees saying, we've changed our policy. Now that we think it's safe to do so, we expect everyone to be in the office at a minimum 3 days a week. So yeah, you've been working remotely, but you're expected back in the office. Well, she was, of course, very upset about that. She had moved. For her to come into the office would mean 2-hour commute each way 3 times a week, which is not something that she was prepared to do. She contacted her employer and she said to them, well, you told me that it's okay to move. You told me I'm not going to need to come in. So what do you expect me to do now? Her employer said, well, that was our policy. We changed our policy. We have a right to change our policy. We expect our employees back in the office. And if you don't come in, then we'll accept your resignation. So she called me, of course, and she wanted to know what her rights are. Well, here's the thing, John. Because her employer gave her the okay to move, because her employer gave her the confirmation that she can continue working remotely, and she relied on that confirmation by her employer cannot take that back now. Her employer is not able to say, you've resigned because I changed my policy. No. So because she relied on it, she's well within her rights to stay home. Now, if her employer decides to let her go because of this, well, they can do that, but they're going to have to pay severance. That's not a resignation. That's not a disciplinary issue. They have to pay your severance. For her, that's probably 10, maybe 12 months of pay. And I'm going to help her get it if her employer decides to let her go. But there's an important reminder there that if you rely on something that your employer said, did, a promise your employer made, if you can show that that promise was made, your employer can't just take it back. Whether it's working remotely, whether it's your pay or the type of job that you do, those things do bind an employer. And if an employer decides to go back on what they promised, to take it back, to change their policy, there are ramifications and there's legal consequences to that. So I think, John, there's some very important lessons there to be learned.
In most cases, though, I mean, this has probably happened to tens of thousands of people over the pandemic, and now it's starting to clear up a little. They feel a little more freedom to bring people back into the office. Under normal circumstances, if the employer hadn't said, yeah, continue staying at home, normally you can't, as an employee, you can't do that. You're expected, you were at work prior to the pandemic. Now that you're coming back to work, you're expected to come back if you're asked to, right?
Absolutely. An employer can expect that the employees go back to their pre-pandemic work arrangements in terms of hours and work location, et cetera. So if you've been off during COVID or working remotely, your employer is able to say, now we expect you to come back to work. And that's absolutely fine. Where this was different is her employer told her, no, it's okay if you move. You're not going to have to come in. You can stay remote. Then they changed their mind. That's what they did wrong. And of course, because of that, there's going to be consequences.
Does it matter if she got that in writing or not, or would it just been a little safer, more ironclad to have that change in writing? Dear employer, this is what you told me, dated, thank you very much.
Listen, anytime your employer makes a promise, an agreement with you, it's always it's a great idea, in fact, to confirm it in writing. A text message, an email works just fine. Employer confirming that we agreed today that I'm going to work remotely moving forward. Whatever it is, that one-liner is perfect and it protects you. Luckily, in this situation, our employer is not disagreeing that they agreed to it. They just say they changed their policy. But definitely, if you want something to be ironclad, as John said, you really do want to get something in writing. And if your employer is not giving it to you in writing, that's okay. You put in writing yourself.
Firm website, employmentlawyer.ca, employmentlawyer.ca. You can go there. There's contact, things to be learned. There's a media tab as well where you will catch links to our long-running radio show. It's been about a decade we've been doing these across the country. Lots of phone calls every week. People want to know, they want to learn. We take some of the phone calls, as you know, Lior, play them back in this show, and we'll dissect them. We'll take them apart and talk about them. First call for the day from the radio show coming right now.
I was let go from my job. I worked there for over 15 years. I was let go on the reason that they had suspicion that I was opening up my own similar business, so becoming a competitor. They gave me 1 week severance pay after 15 years. Now, it's been 1 year that this has happened. I kind of dropped the ball on everything. I was wondering, is there a way of retroactively getting severance?
Good call.
A lot of things, as you say, John, to dissect here. The first thing is this. He said that his employer fired him because they thought that he was starting a competing business. So let's be very clear. If you're going to be working for a company and competing with them also on the side, that's a huge problem, right? That's not something you're able to do. And if your employer were to find out that you're doing that, yeah, they can let you go for cause and not have to pay you anything in most cases. The reality is, though, that your employer has to prove that you're doing that. You don't have to disprove it. And if you're not doing it, but your employer suspects it anyway, if they want you gone, they have to pay you severance. And listen, John, after 15 years, unless this guy truly was trying to compete, in secret against his employer, he's owed much, much more than that. Now, he says that it's been a year. The good news is that there's a 2-year limitation period. So if you've been let go, you have 2 years from the time of termination to pursue the matter, to ensure that you get your full severance. Now, that's a very strict 2 years. It's not 2 years and a day, it's 2 years. For him, it's been a year, so he's fine. So the question, of course, becomes, the main question perhaps, is after 15 years for this gentleman, he was paid 1 week severance. What is he really owed? Well, rather than me just tell you, I'm going to show you, as I always do. I'm going to go to pocketemploymentlawyer.ca. I'm going to use the severance calculator, just so you can see how it works. Let's plug that information into the severance calculator, and let's see how much this person is owed. So we know that this person has been there for 15 years. Say he's 58 years old in a technical role. He was paid 1 week severance. As you can see at the bottom of the screen, what he's actually owed, his actual severance entitlement, is 16 months pay. That's 16 months. That is a huge, massive difference between 1 week and 16 months. You know, with a salary of $70,000, that's a difference of over $90,000. So that's how we use our severance calculator, which you can find at pocketemploymentlawyer.ca. And that is also an important reminder that whatever the company offers you, you do not sign until either we've spoken or you've used the severance calculator.
You know, it's interesting, Lior, with this particular call that we took a short time ago, there's been a big increase in people doing, you know, side hustles with the pandemic. They've either lost their job or they've had their hours restricted, so on and so forth. So they're pursuing other things to make a little money. Are you always wise to, even if it's not a competing business, are you always wise to let your employer know, I'm doing this on the side, it's going to be taking this many hours, but it's not going to interfere with my job with you, or you don't need to do that?
Well, if the job that you're doing on the side has nothing at all to do with your employer, it's a completely different industry. You know, for your employer, you work in IT, and on the weekend you work at coffee shop brewing coffee. Well, it's not going to really be any of your employer's business at that point. So as long as you can do your job, it's fine. But if you're going to be doing something that may be somewhat similar to what your employer is doing, even though it's not competing, I certainly would advise you to tell your employer, to be upfront with them, so they can't say that you were trying to hide something or get away with something. It's always a good idea. The reality is a lot of people now find that they need to work more than one job, and that's okay. But you certainly can't work jobs that conflict with each other or that compete with each other, because, yeah, your employer is going to have a big problem with that.
Going to give you another route to ask questions anytime to Lior and his team, terminationquestions.com. How about that? Terminationquestions.com. Absolutely free and anonymous, of course. Get to the first one today. Lior comes from Lawrence, says, are there any reasons for legally withholding pay? My employer has stressed that business has been struggling recently and that payments will be delayed, though most of my coworkers are still getting their paychecks. Can they do this?
Absolutely not. Listen, one of the most fundamental rights that we have as employees is to get paid for work that we do. We go to work, we do our job, we get paid for it. Yep. That's how employment works. And there's never a legal reason or the legal ability to withhold pay. If you did the work, you have to get paid. Not only do you have to get paid, you have to get paid on the date that was agreed on. So your employer can't say, yeah, I'll pay you, but it's going to be a week late. No, that's a very big violation of employment law rights, violation of employment standards. And now I understand that the business may be struggling. Well, if the business is struggling, they shouldn't have an employee working when they can't pay them. That's just the way it works. So an employee that doesn't get paid properly, even if they're just getting paid late, can file a complaint with the government, can also potentially treat the late payment as a constructive dismissal. Bottom line, John, there is never a legal reason, a legal basis for the employer to either withhold pay or even to delay pay.
First break is coming up right now. After the break, fast facts about bonus payments. That's coming up, so stick around for it. In the meantime, how do you reach out to Lior? I'll tell you how. 1-855-821-5900, the phone number. Email help@employmentlawyer.ca. We'll continue. More Employment Law Show is coming right up. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, we are back. Employment Law Show. Thank you so much for sticking around through that short break. Let's get into this fast facts about bonus payments. This is key for anybody, especially those maybe a sales role or otherwise, Lior. So let's hammer into these right away. A lot of the stuff you're not going to know. That's why we covered on this show. You want to reach out afterwards. 1-855-821 5900, help@employmentlawyer.ca, or pocketemploymentlawyer.ca, the website as well. Number one, Lior, a bonus is not considered discretionary if an employee receives it every year, right?
Absolutely. So you may be told by your employer, just so you know, bonuses are discretionary. We, the company, decide. You may have even signed an employment agreement that says bonuses are discretionary. And you may think, well, okay, I guess they're discretionary. Well, no, not so fast. If a bonus is something that you regularly get, and you regularly get it calculated in the same way and at the same time, it becomes a term of employment. It's something that you're able to count on because you're getting it every year, because you know what's going to happen. So if it becomes a term of employment, your employer can't change it. They can't go back and say, hey, remember when 6 years ago we told you that the bonus was discretionary? Well, guess what? This year we're not going to pay you the bonus. No, they can't do that because over the last 6 years, it became an essential and a regular term of employment. So the real question is not, did the company say it's discretionary, or did you even sign something that says it's discretionary? The question you have to ask yourself is it a regular part of my compensation? Now, if it's a bonus that sometimes you get, other years you don't, well, clearly at that point it is discretionary because it's not regular. But if it's regular, both in terms of either amounts, the way it was calculated, and the time you get paid, it's an essential term of employment. And an example I always like to use is think of the famous bonus for Clark Griswold in Christmas Vacation. Well, he wanted the bonus to do the pool. Well, think about the problem that this created for him when his boss decided not to pay him the bonus. Well, because he relied on it. It became an essential term of employment. So if your employer decides this year we're eliminating bonuses, well, no. That could be a constructive dismissal. That's something that you could potentially take legal action for. Your employer can't just do that.
No, if you kind of got a bonus, it was the Jelly of the Month Club. You know, it's the gift that keeps giving the whole year through, Clark. But, you know, he got his bonus in the end, right? So there you go. Number two, fast facts about bonus payments. Severance packages should include all forms of compensation, including that bonus, right?
So we talked about getting your bonus when it's supposed to. Well, you're also supposed to, and you also must get your bonus as part of your severance. So I'll give you an example. So let's say your bonus is usually paid in January, okay, and you get let go in November. Okay, well, you have to get the bonus accrued for the year up until November, and then also get the bonus over the severance period. So if your severance is 9 months pay, you have to get 9 months worth of bonus as well. That's because your severance has to include all components of your compensation. So salary, benefits, commissions, bonuses, includes that as well. So if your employer doesn't account for your bonus as part of your severance, well, that's a wrongful dismissal potentially. They owe you that bonus. So you always have to remember, you ask yourself this, if I would have continued working, would I have been eligible for the bonus? If the answer is yes, then you also have to get it as part of your severance. Your employer can't say, well, you're not going to be here, so we're not going to pay it to you. Well, the reason I'm not going to be here is because you're letting me go. So no, you have to get paid your bonus as part of your severance as well.
Is this sometimes you hear employers who are trying to be cute and they figure, you know, bonus time's coming out in June. Hey, I got an idea. I'm going to let this guy go in May. That way I can avoid the $10,000 bonus I owe.
I know it sounds awful, and it is awful, but unfortunately, I've seen it happen more times than I can count, where the company is trying to pick a convenient termination date to avoid paying either a large bonus or a large commission payment that an employee is owed. It doesn't work, okay? If you've earned your bonus, you've earned your commission, you have to get it paid. And an employer that tries to avoid paying that by kind of messing around with the dates, not only is going to still have to pay the bonus, they potentially would have to pay other damages for acting in bad faith. So a very bad idea for an employer to do that.
Bonus fast fact number three. Right now, employment contracts may limit an employee's right to a bonus as part of their severance. How about that?
So we talked about the fact that you are owed your bonus as part of your severance. Well, an employment agreement is able to change that. And able to take away the severance you're owed as part of, take away the bonus you're owed as part of your severance. So an employer can stipulate in an employment agreement that if we ever let you go, your severance is not going to include the bonus. Now, here's the thing, and here's what I want you to know. A lot of employers try to do that, have that language in an employment agreement. The good news is that in over 90% of matters, they don't do it properly. They don't properly exclude the bonus, which means you are still owed the bonus as part of your severance. So if you believe, well, my employer is telling me I don't get the bonus because I signed an employment agreement that says that in my severance it's not going to include the bonus. If you believe that's the case, let me see the agreement. I'm going to give you a 90% plus chance that despite what you may have signed, it doesn't exclude your bonus, it doesn't take it away. But always be very careful and mindful of that employment agreement. Another thing you want to watch out for in an employment agreement is there something there that may take away your future bonus?
Especially if that employment agreement has come late in the game while you're already working there. It might be something they're trying to change on you, right?
Always a problem if you're already working and your employer wants you to sign a new agreement. Yes, one of the purposes of it may be to take away your bonus. So please be smart. Don't sign an employment agreement, a new employment agreement, without understanding what it says. And to understand, just send me a copy. Let me read it. I'll tell you what it all means.
Okay, bonus fast fact number 4. Let's get the last one. Employees who are not paid their annual bonus may be able to get severance through a constructive dismissal. Explain that.
So taking away your bonus is essentially giving you a pay cut, right? So if you usually get $10,000 a year bonus and this year you don't get it, well, you essentially are getting a $10,000 pay cut. And what do we think when we talk about reductions in pay or pay cuts? We have to think constructive dismissal. An employer does not have a right to change terms of employment, including taking away a bonus or reducing pay. And if an employer does that, it may give the right to the employee to treat that as a termination, call it constructive dismissal. That means you get your bonus and you also get your severance. Now, it's not every change and not every time your employer takes away the bonus where it's automatically a constructive dismissal. We have to understand the terms of the bonus plan. We have to understand the dollar amount that is being taken away. But if you're ever in a situation where your employer doesn't want to pay you the bonus or decides this year it's not going to happen, before you agree and just continue working, or certainly before you sign anything, you have to give me a call. Let's talk about it. Let's explore constructive dismissal. That may absolutely be an option that you have.
Again, these points taken, you know, if you're ever unsure, as Lior says, call them 1-855-821-5900, help@employmentlawyer.ca. Want to get to our second phone call? Again, Lior, a radio show across the country, employmentlawyer.ca, to find a station that carries it, about an hour long in most cases. And you can actually call in when we're live and ask some questions as well. Phone call number 2 from the radio show coming right now.
Company that has multiple branches, and each branch has a manager. If one manager goes kind of rogue or off company policy and causing a toxic environment in the workplace, what can be done? Is that even allowed? Can one person just have their own set of rules?
Well, certainly if you believe that what your boss, your manager, supervisor is doing is improper, and certainly if it creates a toxic work environment, if you think now it's becoming a harassment situation, you have to tell someone, okay? You have to let the company know, whether it's HR or the owner, make sure that they understand what you're dealing with. Now, it's possible that the company is okay with the employee, the supervisor, creating their own policies, depending on what those policies are, but it still can't create a toxic work environment. You still can't be bullied. You can't be mistreated. And if you are mistreated, the company must deal with that. The company has to investigate. They have to take measures to take away that mistreatment and to eliminate toxic work environments. And if they don't, that's where I get involved, because there's legal consequences. So the best advice I'm going to give you, if you're facing a bully in the workplace, a toxic work environment, is tell someone in writing, okay, like the boss, the owner, the HR manager, whoever the right person is, give them that opportunity to fix the problem. If they don't fix it, you got to call me right away.
And if the person doing the harassing is the top-level boss, got no one to reach out to. That's why Lior is there again. Skip it and go right to Lior. We'll take a short break and do another phone call from our radio show. But in the meantime, 1-855-821-5900 and help@employmentlawyer.ca will continue. This is the Employment Law Show. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. A few minutes to go on the Employment Law Show. Welcome back to it. Reaching out to Lior. I'll give you the number again, 1-855-821-5900. Don't be bashful. Just give Lior and his team a call. Have a chilled out, relaxed chat about whatever issue is that comes up for yourself. Maybe it's something you've watched during this 30-minute program or here on our radio shows. You can always call that number, help@employmentlawyer.ca. It's a good route as well through the email. I did mention the radio show, Lior. We'll get to phone call number 3 from our radio show right now.
Today I found out that I'm going to be asked to report to a C-suite executive. I'm already a C-suite executive, and it's not acceptable to me. Some of the reasons that were discussed as to why relate to issues that I've documented, and they're incorrect. At least circumstances were outside of my control. I've only been there 3 years, and I'm 60.
Listen, John, it certainly sounds like a demotion, like the company thinks that she may be doing something wrong, so they're going to put her in a different role that's maybe a lower role, whether it's in terms of the organizational chart of the company or maybe from a prestige standpoint, it's a lower role. So this is an important reminder that I can give you that, yeah, an employer does not generally have the right to demote you. An employer can't put you in a lesser position, even, by the way, if that new position pays the same, but it's obvious that it's a lesser position. That also is not something an employer is allowed to do. So what does this all mean? It means that she may be able to treat the demotion, as well as the fact that she's being written up for things that she says are false. She may be able to treat that as a constructive dismissal, because what the company is actually doing is they're trying to potentially push her out. Well, if they're trying to push her out, they may get what they want, except the law looks at it as a termination. If she were to leave, it would not be a resignation. It would be a termination. She would be owed compensation. She would be owed severance, because she's not leaving because she just decided she doesn't want to work there anymore. She's leaving because she's been demoted, she's been improperly treated, because her employer made the work conditions not good, not favorable. Same thing with you, by the way. If your employer is doing something to you, they're trying to push you out, they're trying to create a situation where you don't want to work, you actually may be able to leave and still get severance. It's not a resignation, but of course, before you resign, before you do anything like that, you have to call me. So the last question for this lady is, okay, we know that this could be a constructive dismissal. Yep. Now that we want to know, well, how much is she owed? How much compensation and severance would her employer have to pay her? So last segment here, let's go once again to pocketemploymentlawyer.ca, and let's use our severance calculator tool so we can see how much she's owed. Okay, so let's do that right now. We know that this lady has been with her employer for 3 years. She's 60 years old. She's in an executive role. Even though she may be the one leaving because of what her employer did, because it's a constructive dismissal, she's easily going to be owed about 6 months' pay. And by the way, John, that could be even more than that. It could even be as high as 9 months' pay. So 6 months' pay is what we're looking at here, even though, again, she is not let go. Same thing with you at home. You may not have been let go, but you may be able to leave if something has happened. To find out how much you're owed in any situation where the company owes you severance, just go to pocketemploymentlawyer.ca and use our severance calculator tool.
Yeah, the fact that she's 60 played a big part in that 6 month severance, because that number seems pretty good.
The older you are, the more severance you're getting. And certainly at 60, you're going to be owed more severance than at 40, no question.
There you go. Lots learned. As I mentioned, over 30 minutes. You want to tune into our radio show, employmentlawyer.ca. Maybe your phone call will get on the air. But to reach out to Lior, now that we're done for this particular show, number 1-855-821-5900. Email is help@employmentlawyer.ca, and always pocketemploymentlawyer.ca. Right there, you'll find the severance pay calculator as well. We'll do it all again at a later show. Thank you so much for joining us. We'll see you next time on the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.